See, there is a statement on solemn oath made before the Supreme Court that each and every allegation is false, baseless, and malicious in these various FIRs which have been deliberately planned and filed in different states for the same cause of action. Therefore, the matter is pending before the Supreme Court. My client intends to fully cooperate with each and every query and question put by the Mumbai police. That is why we are here. Each and every allegation has been denied before the highest court of the land. Matter is pending, and that is why we are proceeding towards the police station.
Okay,
Today we are going to discuss about judicial accountability, judicial reforms, press and media freedom, trials, recent cases and many more. But the prime reason to have this discussion is we all are suffering from lockdown fatigue. And this kind of conversations, this kind of chats can keep up our spirits. So without wasting much time, now I would request Dr. Nidhi to take this forward.
right. What have been your experiences of interacting with bureaucrats and with government officials at all levels in a long span of the career that you have had? I'm sure you must have had some very pleasant experiences and there must have been some unpleasant experiences. So how easy or how difficult is it for a lawyer to deal with the other two pillars of a democratic polity?
See what happens. I'm a defense lawyer. I'm defense counsel. So I'm always pitted against the government agencies, arguing on behalf of my clients. So it happens that at some stage, perhaps if I get some favorable order or if I'm kind of exposing the whole thing in court and in order to prove my client's innocence, tempers do get flared up sometimes. But, you know, with all this experience down the line, it doesn't ruffle me now. As far as hearings are concerned, I also have appeared in thousands and thousands of personal hearings before commissioners, and they are all ultimately bureaucrats. But more or less, my experiences have been pleasant. Actually, it's better in life to forget the unpleasant and move on.
Okay, what is your take on the current legal education, the status of legal education in India right now?
Fantastic. You have national law colleges everywhere. You have other colleges also. And the best part is that now we have so many different type of moot courts where young boys and girls, in fact, I have judged so many moot courts when I have been called upon. And I see kids coming from Delhi, kids coming from Assam, kids coming from Kashmir, and really articulating their propositions. In fact, I was hopeless. But now seeing kids today, I am amazed. And that is because of digital revolution. Today, we have got all judgments available at the click of a button.
Right. Sir, since a lot of our judicial system was inspired by the colonial system, we kind of have to accept that we have taken a lot of things, borrowed a lot of things. So do you feel that there is very little of our own, and now probably is the right time to infuse some Indianness into legal education, infuse some Indianness into legal practices, and infuse some Indianness in the way the legal system has evolved? Do you think it lacks Indianness?
In fact, I think it's the other way. I think that our ancient civilization, and I'm very proud of it, our heritage, we had Mimamsa principles of law. Thousands of years back, they were written. And I think that they were actually inspired by our system. And they wrote their laws based on our. But you see, whichever system you go in the world, basic common sense and logic is there in all laws.
Right.
Whether it is written, unwritten, or common law, or something that has developed as a matter of practice. I have been, whenever I have been abroad, at that time, I have made it a point to go and witness court hearings. And when I came back home and shared my experiences with my brothers and sisters over here in the bar, I think our system is equally on par with other systems all over the world. Let me tell you, though we are following civil procedure code, criminal procedure code, and all these are criminal procedure code of course 73, but there are many acts which are 100 years old. We need to have a relook at some of those. But our constitution, the highest law of the land that we live by, and all our rights and obligations are governed by that. That was under the great authorship and chairmanship of Dr. Rajendra Prasad and Dr. Ambedkar. So that is an Indian product. Though Dr. Ambedkar in those times studied constitutions of various countries, and that gave birth to our constitution. So our Indian constitution is unique and unparalleled in the world.
Right. Sir, why I asked this question, because we have a very interesting question from one of our viewers, and she asks that how can dharmic principles be incorporated in the teaching of Indian constitutional and procedural law? That's her question.
It is already there. A very good question, but it is already there because, as I said, that we had our Mimamsa principles of interpretation of law, and in fact, Justice Markandeya Katju has written a book on that, and I think our young students should grab a copy of that. If there's a PDF available on Google or something, and let me tell you, they are based on logic.
Sir, because we have understood law, or law is majorly understood to be a matter of logic and interpretation, then how does culture, society come into interplay with law? Because obviously the overarching principles might be very similar, but the way the legal system functions might be very different in context to changing culture and changing society. So how do lawyers take culture and society into account when they are representing their clients in a case? Does it play on their mind?
Definitely it plays on their mind because ours is a very unique country. We have different practices in different parts of our country. And the law as it is developed is also keeping into account practices which are commonly practiced. There could be a certain ritual which now and courts have taken into account certain rituals, certain practices, provided they are not in conflict with our written law or the Constitution of India. So I think there is a beautiful interface, and ultimately all these laws, all these institutions are for the public good. Ultimately it's a public and the society that is concerned, because if there was no people or there were no citizens, then we didn't need these laws and these institutions. So there is a beautiful intermingling, like Ganga Jamna Saraswati Milan, and it's working well.
Sir, I'll come to the question of media freedom next, particularly because you have been in news, you have been seen on TV very recently in a case handling media freedom or speaking for media freedom. So we want to generically talk about media freedom, number one. And number two, we also want to talk about the concept of media trial. So in the past decade, especially in the double murder, Arushi double murder case, we saw there was an intense media trial. So how does the practice of media trial, the way it has evolved in the past decade, affect legal practitioners?
Very, very important and very, very pertinent question you have put. And I think with the limited time that we have at our disposal, it may not be giving real justice to your question, my answer. But let me try whatever I can.
Sure.
Look, I always believe that if we are all accountable, we are all responsible. We are educated people. And therefore, that also applies to the media. Now, there are very, very sensitive matters. And I am, with my experience, I know a lot of reporter friends. They know that this is the Lakshman Rekha, which we don't need to cross. But what happens in a matter that is sensational? What happens where there is a matter which has got great ramifications? You know, it is the talk of the town kind of thing. Naturally, there is going to be a curiosity, and naturally, it is the duty of the media to report the actual fact, because people read. People are into social media. People are reading newspapers. So it is the duty of the journalist also to, kind of put out the story so that the public gets aware and public understands various facts which transpired or whatever transpired in court. But there are cases where their matters are very, very sensitive. For example, there could be a sensational murder case where certain witnesses, their names should not be disclosed. So media is, and which is my experience, that definitely media is very, very responsible. But certainly we are all human beings. We read newspapers. We have WhatsApp groups. We discuss all sorts of things. And ultimately, it definitely makes an impact on your mind.
Right.
Now, in the pure stream of administration of justice, there should be no pollution. It is the quest of every court trial that the judge tries to arrive at the truth. The prosecution will try its level best to prove its case. The defense will try to prove the innocence of its client. Ultimately, it's for the judge to decide. So this is a very, very delicate issue. And sometimes it does happen that sometimes there is a little bit of a transgression here and there. But overall, I think our media is extremely responsible, and they know to what limits they can, go to and report what the actual fact is. You don't need to run a parallel trial on the side and come to your own conclusion, because that is the judge's job.
Right.
So more or less these things are understood.
Yeah. Sir, a few years ago in the Rohtak Bravehearts case, because I remember reading about it a lot, the media ran a completely parallel investigation trial in which they declared that the boys who were accused of teasing these women in a bus in Rohtak were already guilty, and ultimately the boys were acquitted in the Haryana High Court. And the first statement that they made was that we want an apology from the media because it has ruined our character, it has ruined our lives, it has ruined our aspirations and dreams. So on one hand, probably the legal fraternity faces a media trial, and secondly, there's also a lot of public outcry and public emotions that are probably involved in some cases. For example, in the Nirbhaya case, when the hanging got endlessly delayed, there was a lot of vent and frustration and anger in people that why is this happening? So on the one hand, you have pressures from the media to some extent, and second, you're also bogged down by public emotions. So is the legal fraternity in some kind of tussle? Are you being stretched over that, okay, we are facing some expectation from the media, and on the other hand, there are also people who feel that, okay, why does this happen? Especially in the context of the Nirbhaya case, I want to put this question.
No, I'll tell you something. As lawyers on both sides, the prosecution and the defense, our main focus is our case.
Okay.
We don't need any assistance from the media to make our case stronger. The prosecution has to present its case, the defense will present its case. It's for the judge to decide. So the focus is do your best for your client, whom you are offering your services, and it's the judge ultimately has to, kind of decide. But let me give you an example. You give me two examples of the famous cases. There are so many other cases that, and this discussion could go on and on.
Right.
But I remember a very, very sad case in which I was in the courtroom that day, and in which the father was accused by the teenage daughter that he used to rape her. And the father was ultimately acquitted in that case, because the father was in jail for almost 8 months. The POCSO is a very dreaded act. It can be misutilized also.
Right.
Father was in jail for 8 months, and when the girl, because these cases are normally held in camera, I was there when the order was pronounced. The girl actually had seen the father in his tattered clothes and he had lost weight. And that time she broke down and said that because I was not getting pocket expense, I falsely implicated my father. Now, so you have such tragic cases, and therefore it is of utmost duty of all the people who are concerned in this administrative justice, the lawyer, the defense lawyer, the prosecution, and the judge, to be sensitive in such cases, because many a times we see that wrong people are implicated for XY reasons, and that makes the job of the judge even more onerous.
So, sir, we are moving to two last questions. Because all of us are digitally connected, we are under a lockdown still able to have this conversation. So, as a lawyer, how have you adapted to digital technology? Or you can also comment about this generically. How has the legal profession adapted to digital technology and the benefits and the challenges that it brings around?
Fantastic. I think it's great. You're sitting in a courtroom and there is a matter which you're about to argue, and something pops up on your screen, and that's a judgment perhaps in your favor.
Okay.
So, what I'm trying to say is that it has really assisted our profession.
Okay.
Today, at the click of a button, you can get judgments which are terrific. And the software is so well developed that you can track the judgment also, that how many times it has been followed, where it has been distinguished, or where perhaps if there is an appeal filed against that, if that has been set aside also, maybe by the Supreme Court. So you don't mislead the court. You are always vigilant enough to put a judgment before the judge, which still holds the field in your favor. So I think it's terrific, and it has greatly assisted me in my journey.
Okay, but has this digitalization seeped into the ground level of the judiciary? As in, do we see courts at the district level, at the state level, enthusiastically using digital technology, or is it only
Yes.
few people?
Yes, yes. Yes, I'm telling you, because I argue matters in the magistrates court, I argue matters in the sessions court, not only in Bombay sessions, I go to even Alibag sessions, I go to Dindoshi also. And I have appeared in Palghar Sessions Court also. Everywhere, it's so easy, these tools, SEC Online, etc., that the judges are completely aware of the fine legal nuances and the latest case law.
I want to understand something about the Constitution. The Constitution is our sacred document, but a lot of people, a lot of Indians don't know enough about it. So, how do we take the Constitution to the people so that it becomes a document that doesn't remain confined in our government offices, in our courts, and people actually own it up and understand its essence?
Constitution is a living document. There have been more than 100 amendments since independence, right? And Constitution has tried to keep up and evolve with the changing. Apart from the Constitution, we have judge-made law, that is our Supreme Court. And under the Constitution, the orders of the Supreme Court are binding across India because it is the final court, and we have great respect for it. But let me tell you this, that it is not very difficult to understand our Constitution. What is the most critical chapter according to me? Because there are many other, there are the directive principles, then there is the elections and all this prime minister, president, all those sections. You may refer to it when you need it. But your chapter 3, that part 3, the fundamental rights, I think that is enough, which is the basic structure of our Constitution, which can never be shaken or abridged. That is important for every citizen to understand. Everyone is equal. That is what Article 14 of our Constitution says.
Great. So I'll hand over to Omkar sir, because we had a lot of questions for you, because we put it out on Twitter, Facebook. So a lot of young people were interested in asking you questions, and Omkar has a few of them. Very interesting. So they'd be very happy to have you answer these questions.
Thank you, sir. Thank you. Actually, I was sitting in the audience chair. I was listening to the conversation. It was so much insightful. Your interaction was really interesting. I think it should go on. But we have some questions. So I'll read it out, sir. First question is from Praveen Belapurkar. He's asking freedom of expression for an individual and freedom of expression for the media, especially electronic and social media. Which one is a priority according to the Indian Constitution?
Well, before you go to Article 19 and talk about freedoms, and let me tell you this, if you say that you have a right or a freedom to do certain thing, that freedom or right is not absolute. It comes with its obligations. It comes with its responsibilities and limitations. A particular person does not have the right to just write anything or everything that he feels like. Because remember one thing, now the Supreme Court, apart from the right to privacy, has held the right to reputation also to be a constitutional right of a person. Because that is an integral part of your life and liberty concept. Article 14 is paramount. All are equal before the law. One should never forget that.
Okay, so sir, the next question is, what are your views on post-retirement assignments for High Courts and Supreme Court judges?
Okay. Look, I have absolutely no problem as far as post-retirement assignments, because I have appeared in many arbitrations, and these days, the biggest arbitrations that are even cross-border that are going on, we have our retired judges as arbitrators, and they are doing a wonderful job, because the colossal experience that they have amassed during their journey in the judiciary is helping over there. There are so many tribunals in our country that the chairmanship or the presidentship is reserved for a former High Court judge or a Supreme Court judge. There is absolutely, I don't see any problem or any difficulty over there.
This question was put by Punyadhara Doshi, who is a student.
Okay.
Very good questions by students. It has been a fantastic interaction, and I've thoroughly enjoyed myself. I may start looking few years younger after this chat. Sure.
As a gesture of give back to the society, shouldn't the Bar Council request its members to take up the cases of those underprivileged for whom justice is unaffordable? The government has set up NALSA, but that does not absolve lawyers of their moral responsibility.
No, see, what happens is that we already have legal aid clinics. We have NGOs, and I'm regularly approached. So whatever little bit from my side I can do, I do. And there are many others, other lawyers like me, who give up some part of their fee earning practice and do pro bono litigation, pro bono work. So there are legal aid clinics, and if a person does not have a lawyer, the court always helps and enables him to approach the legal aid clinic. Our High Court also, there is a system where you can approach the legal aid clinic and get a lawyer appointed. There are so many NGOs who are doing fantastic work. So I think it's there. It's already there in place.
Sir, here is a question from Dr. Preeti Niranjan. She's asking, in case of exercise of free speech under the Indian Constitution, on what grounds can FIR be filed? How relevant these FIRs are, and if the FIR is found to be wrong or malicious, what accountability does the one who has filed it have?
Well, so therefore the CRPC is very clear. We have section 154, which says that whenever a cognizable offense, there is an information received by the police of commission of a cognizable offense, he has to lodge an FIR. But two judgments, the names which I gave, and I'm requesting this particular person who has asked this question to read two judgments of the Supreme Court, and they are available on social media. That is Lalita Kumari, D.K. Basu, and Arnesh Kumar. That is three judgments. I'll repeat the names again. D.K. Basu, B-A-S-U, Lalita Kumari, and Arnesh Kumar. These are the three judgments which will answer her questions. And having come out from the stable of the Supreme Court, I think that will answer perhaps every possible angle of her query, rather than a humble person like me.
So I have this one question from Rudvi Dattan.
Last question.
Yeah, this is the last question. She says that the media and the police they function as independent yet interdependent institutions. But in the recent time, this relationship has been exploited. She says that the police also control the media, and the media also portray a very negative picture of the police. So how fair is it for one institution to overpower the other? Because we are talking about separation of powers and accountability. So how does this, how can this be viewed?
This is not a complete legal question, but let me answer this in only one sentence. That, okay, we know what happens as far as the police is concerned. We know that media is doing their job also. They will keep on clashing, they may not clash, that is their problem. Judiciary is the last bastion of hope in this country, and judiciary will decide cases on the basis of evidence which is brought before them or presented before them.
Great. So even though we are becoming...
Sir, I have one question.
Okay.
You know, sometimes as they
Shall I go for it, sir?
wait, the chat began with a champagne which was full of bubbles and bubbly, but now all that soda and fizz has gone out of it.
We are becoming a bit greedy, but we don't understand.
Yeah. So, sir, in the current times, the way justice is provided, the justice is delivered. Is it the same way? I mean, what was the procedure in ancient times? Can you throw some light on it?
Well, in ancient times we had kings, and the king decided your fate, or whatever. You know, there is a famous saying that equity varies with the length of the chancellor's foot, that kind of thing. So he could behead you if he wanted. He could do whatever. Thank God that monarchical system is gone. Thank God that British are gone. And today we have our constitutional courts which are there. There are well-defined laws. There are judicial precedents. There are arguments which take place in open court. The public witnesses everything. The media is witnessing everything. The judges hear both the sides, give them so much time. In fact, that is what I have always been saying, that there should be some rationing of time for both the sides. How much can a judge sitting on the dais hear for hours and hours, hours and hours? I mean, he is also a human being. So therefore, according to me, the present setup that we are enjoying, and it is our privilege as citizens, is the best possible system.
Correct.
Great. So, sir, even though we are becoming greedier, but we know that you're very busy and we'd like to respect your times, and we would love to invite you to Baroda whenever the lockdown is over, and whenever you can come and travel to Gujarat. We'll be very, very happy to host you. In fact, the university here has a very vibrant law department. So it'll be a pleasure to host you whenever you can.
My
come.
great grandfather was from Baroda, so I originally.
So you do have a Baroda connection, which is nice,
Yes,
which
yes.
is why we could connect so easily and so well.
Pleasure.
Great.
It has been
Thank you.
a total pleasure and privilege for me to interact with both of you too.
Thank you, sir. Thank you so much, and
Our pleasure, sir.
take care.
Thank you.
Yeah.
Thank
Bye. Bye.